The parties have agreed, first of all, that they're, and have jointly requested that there be a continuance of the trial from the April 4th date. And so we have done that, and this is the schedule that has been arrived at. March 7 at 1 o'clock p.m. will be a hearing, motion hearing and motion arguments in court. April 4 at 9 o'clock a.m. will be a specific hearing, a Daubert hearing, which will concern shoe print expert testimony. That is subject to the court's ruling on a motion right now, but the parties have agreed that if the court orders a Daubert hearing, that's when it will be held. May 2nd at 1 o'clock p.m. will be another hearing, motion and arguments. Again, the motions, any motions that are right to be heard at that point, including any motions filed after today, may be heard at that time. May 16 at 1 o'clock, another motion. That one, it was specified, will be a hearing on a motion to suppress. Then July 5 through July 14, 9 o'clock a.m. on each of those days, we'll be working on seating a jury, including completion of jury questionnaires. We'll include that. And that may be at another venue other than the courtroom here. We'll try to make arrangements for that where we have more spacious, I guess, accommodations. August 8 at 9 o'clock a.m. will be individual voir dire. August 15 at 9 o'clock a.m. Will begin also a day of individual voir dire. Then the trial will start on August 29 at 9 o'clock a.m. With the general voir dire of the jury, and then upon completion of that, opening statements, evidence, and so forth. We've set 30 days, a month down for that trial, and if we need more time than that, we'll arrange for more time. Now, have I correctly, Ms. Canepa and Mr. Parker, have I correctly stated the schedule as agreed upon by the parties?
Judge, I just wanted to clarify, because I heard, and perhaps you meant this, but it just wasn't clear from how it was stated. But the week of August 8th, 15th, and 22nd, it would be every day those weeks. Okay. So it would be for individual ones.
I had it down that way.
No, I didn't.
That could be my fault too when we were in the back, perhaps so. But I just wanted to clarify.
So it would be the week of August 8th, the week of August 15 for individual voir dire, and then with trial beginning on August 29th. So with that amendment, is that correct? That's what the parties have agreed on, correct, with respect to the schedule?
Correct.
Ms. Canepa, correct?
Yes, Your Honor.
All right. Is there, I should state for the record's sake that the defendant is present here. I did say that, I believe, and he is in civilian clothing without the visible restraints. Is there anything further to be placed on this record today? Yes.
I'm sorry.
Is there anything further that the defense wishes to place on the record?
Just a couple of matters, and we don't need to go through the dates, but that we have selected approximately 3 or 4 days that the defense will be meeting with the prosecution, but at a separate location, not here at the court.
Away from the court?
Yes.
I should say, I'd ask you if there was something else. There is something else I want to do, and that I want to address the defendant here. Mr. Wagner, are you satisfied with the access that you're having to your attorneys?
Yes, sir.
And are you satisfied with the services that they're providing on your behalf?
Yes, sir.
Do you have any complaints or any questions that you wish to put on the record? Mr. Parker, is the defense, and Mr. Nash, is defense satisfied, defense counsel satisfied with the access you're being provided to your client?
Yes, we are satisfied.
Absolutely.
Is there anything further from the state?
Your Honor, if the court would indulge us, if you could just ensure that, I believe there has been a time waiver filed in this, and I realize this is a joint request for continuance, and they've filed several motions that would arguably toll time as well. But if the court would just confirm that, time is being waived for the period of this continuance.
Kathy, can you do that with electronic docket?
Print it from the other one, I'll have to get it. Should shut it off.
I could probably ask the defense counsel, what's your understanding with respect to it?
You know, my understanding is that we have signed an indefinite time waiver. I don't know when that happened, but there was no limitation on it.
Well, show it to me, but since attorney, it appears to the court as if there was a specific limited time waiver signed back in November of 2018, and then there was a general time waiver signed in July of 2019. But go ahead and show.
I'll just make a copy.
Let me just ask defense counsel, based upon that, are you satisfied that the defendant has waived his right to speedy trial in this case?
We are satisfied.
Is the state satisfied?
Yes, Your Honor, thank you.
Is there anything further we need to place on this record?
Your Honor, I just wanted to address the daughter thing just briefly. Again, we've had discussions in chambers. Defendant filed a motion, I can't recall when, I think in December. We filed a response. I did add some facts, which simply are the proffers of information that was gleaned from the proffers of both Jake and Angela Wagner, just to again support that the conclusions of our expert obviously have been confirmed to be accurate. So we certainly are not conceding, I guess, is just the point that I wanted to make. I know that the court knows that. But I don't think I need to say anything more. I certainly, the court will make its ruling based on the filings that we've had, and I have secured the availability of the expert should the court choose.
the court will look at that and make a ruling on it. But it's my understanding that if the court does sustain the motion in order that a public hearing be held, that the expert's calendar has been cleared for, in this case, for April 4 at 9 o'clock a.m. Is that correct?
That is correct, Your Honor.
Is there anything else we want to put on this record?
No, thank you, Your Honor.
Nothing further.
Not that we are adjourned.